we may move to Professor Marva Khan, who is a professor of practice at Lahore University of Management Sciences. She did her law at LUMS and then she did her LLM at Harvard Law School. She has been teaching at LUMS for past several years, and she has also been an instructor at the Punjab Judicial Academy. So over to you, Marva Khan, and she'll be talking about constitutional law in Pakistan.
Thank you so much, Zubair, for that very kind introduction. I'm going to be talking about constitutional law, and it's an extremely broad subject. So there's no way I can do justice to it in 20 minutes, but I think I would like to go over, personally, I feel that the most integral parts of, in terms of understanding constitutional law is if you understand the basic concepts, if you understand why things work a certain way, if you contextualize our current constitution, it helps you remember and retain and also sort of to better comprehend our overall constitutional framework. So I'm just going to be glancing over some concepts with you today. In terms of books to use, so the ATC guide or the syllabus essentially mentions Ahmad Khan's book about constitutional history. I think it's very good because it's a sort of succinctly or sort of summarizes the constitutional history of Pakistan. So it's good to look at that. But considering the breadth of the syllabus, I wouldn't recommend sticking to this alone. I mean, I know that you've already studied your BA-LL.B at this point in time, but I mean, my go-to book for constitutional law has always been Judicial Review of Public Actions by Justice Fazal Karim. And it's very in-depth. So I mean, for a 10% written exam that's only weighted to 10%, that's too much information for you, but you can essentially go there for any concepts that you are looking to learn more about. So let's start off with a sort of contextualization, right? So where does the Pakistani constitution come from? So when you're looking at the Pakistani system, we're sort of a hybrid common law country. I say hybrid because our current system gives or reflects the pre-colonial system or the systems that were in place. Some of the systems pertain to the Mughal era, some date even back to the Jirgas and the Panchayats, which predated the Mughal regime. So you have an essence of that. And then of course, even post-partition, we've had a bunch of regime changes, Islamization period during Zia. So you have a hodgepodge of different systems come together to make what the Pakistani constitutional system is today, right? So, but one essential component, of course, is common law, and therefore it is imperative that you understand where that comes from. So when we look at the British constitutional framework, it's rather different because, I mean, of course, it's also a common law country with parliamentary supremacy. So that's the one point where we are sort of distinguished, that even though we have a parliamentary system, we have constitutional supremacy because the constitution, of course, is the overarching document. Because the British system essentially comprises of multiple constitutional statutes, which can be amended or done away with by a simple majority. Whereas as you should hopefully know by now, when you have a constitutional amendment, you need a super majority or 2/3 majority in both houses to essentially attain this particular goal. And another point of distinction, of course, is going to be the fact that the UK government it's a combination of limited or a constrained monarchy with the parliamentary system. We, of course, do not have that system in place. Our constitutional framework somewhat resembles that of the United States, but not in terms of the literal text, because if you've seen the United States Constitution is really short, whereas the Pakistani Constitution, of course, is extremely long. So you have that entire system essentially going in place. So you have the entire system in place. And then, of course, the US Constitution is a federal system, so is ours, but our Constitution is very expansive in terms of how the federal system is bifurcated between the central government and the provinces versus what the system there is in terms of the central government and the states. Another thing that's sort of common is the notion of having a Bill of Rights. So in the UK, you have the Human Rights Act, and then you have some other statutes which grant certain rights to civilians, and also grant a remedy against the state when those rights are not being protected by the state itself or are conversely being violated by the state. The US Constitution, by virtue of subsequent amendments, came up with a whole Bill of Rights, and some of our rights you might find will be drafted in a language similar to that of the United States, which is why when you actually see a lot of our constitutional cases, the jurisprudence coming from our constitutional courts, they tend to rely a lot, not just on British cases, but more so on American case law as well, right? So if we go forward to the current, I mean, our local constitutional regime, we've had 3 constitutions to date. The first 2 constitutions essentially were very short-lived and also were very executive-centered. When I say executive-centered, I'm actually talking about excessive powers for the dictatorial regimes, which, or you can say, if not a semi-presidential system, was a very, very strong presidential system. It was a presidential systems much stronger than what you have or have had in the United States. So those 2 systems essentially really can't be compared. When I say semi-presidential here, it's not because of how weak or strong the president is. It's essentially because of how the system was actually good. So you have a president and then you have a prime minister throughout our history, whereas in the United States, you have a president and then you have a vice president. So there's a dichotomy between how the executive is essentially phrased, right? So, and I'll come to that shortly as well. So that's essentially one thing that you need to bear in mind. When we come to the 73 Constitution, it was initially envisaged as a parliamentary system, but then of course it went through 2 rather long dictatorial regimes, at which point in time we became a semi-presidential system. So the 8th Amendment, the 13th Amendment essentially were the ones that shifted or altered the framework of the 73 Constitution to go towards a semi-presidential system. Conversely, the 18th Amendment is something that's, of course, extremely, extremely important, and I'll come to that. All 3 constitutions in Pakistan also portray or develop a federal system where you have a center and then you have multiple provinces. And this entire framework is something that we inherited from the British. So again, if you've studied Pakistan studies or, even in constitutional law, hopefully you've studied already, that Pakistan, before partition, of course, the Indian subcontinent had a series of Government of India Acts. So those statutes were the constitutional statute of this particular territory. And then once independence happened and once partition happened, both these territories came up with their own constitutional documents, which can't be called statutes, because of course they're at a higher level in terms of the hierarchy. You need a higher majority to alter them, or a higher level of democratic will, essentially a political will, goes into altering the constitutional framework. The federal system was also changed via the 25th and the 26th Amendments, when you had the KP-FATA merger happen. So again, when you're studying for your exam, or when you're revising your exam, there's a few ways to go about it. Number one, you do it conceptually. So what are the basic features or basic elements of the Constitution? You go with them. And then also it's a good idea if you have like a timeline of all the constitutional amendments that have come and in line with the major constitution, like political developments or historical developments in the country. It'll be very easy. It's very easy that way to sort of classify different types of amendments in different categories in terms of what happened when, and it'll help you make a mind map also. So coming to the 18th Amendment, which of course is the crux of, or brings us to the crux of the substance of the 73 Constitution as it stands today. It's the most expansive amendment we've had to date, with over 100 provisions of the Constitution Amendment. This essentially returned Pakistan from a semi-presidential system to a parliamentary form of government. You might have heard about Articles 58 to be 112 to be, by virtue of which the president and the governors could dissolve the national and the provincial assemblies. The 2B clause, which gave them absolute power to do so, was removed. It also curtailed the emergency powers which lie with the executive. When we're talking about the executive, again, we're talking about the president, the prime minister, the federal cabinet, and at the provincial level, of course, we're talking about the chief ministers and the provincial cabinet there. Furthermore, it enhanced provincial autonomy by abolishing the concurrent and provincial legislative lists, which again were something that we inherited from the Government of India Acts, which had 3 legislative lists, the federal legislative list being the 3rd one, and the only remaining list that we have now. The 18th Amendment was also revolutionary in the sense that it introduced three new fundamental rights. So now rights to fair trial, rights to information, and right to education essentially are justiciable rights, part of the constitution itself. It also removed the term limit for prime ministers. It curtailed, the president and the governor's ordinance making powers earlier on, at least actually throughout the semi-presidential periods. The ordinance making power would be absolute. The ordinances themselves were not temporary, but as you know now, the ordinance, if not adopted by the provincial or the National Assembly, as the case might be, is going to lapse. One thing that's sort of remained consistent throughout the history of at least the 73 Constitution is the role of religion, essentially. So how, except for Article 2A, right? So Article 2 makes Islam the state religion of Pakistan. The repugnancy clause, Article 227, which says that anything that's repugnant to Islamic injunctions is going to be void, and that's essentially one of the gateways to the Federal Shariat Court. Those two things essentially have always been there. The repugnancy clause actually is also a legacy of our colonial past, because earlier on, when we were a colony, the repugnancy clause only applied to laws which are repugnant to English laws, and now, of course, it was modified to and replaced with Islamic injunctions. Then we had the Council of Islamic Ideology, Article 228, which was created via the second constitution, and the third constitution, the current constitution, sort of carried this forward. Coming to the legislature, so we have a bicameral system at the center. The Senate is the upper house. You have indirect voting for this. There's a 6-year term, but every 3 years, the elections are held for half of the members of the Senate. The Senate can also not be dissolved, unlike the National Assembly, which has a 5-year term, which is also called the lower house. And there are still, Article 58 still exists. So there are still certain avenues where the assembly essentially can be dissolved. For example, if there's no prime minister and the assembly is unable to come up with a prime minister, the same thing applies to the provincial legislatures as well, which are unicameral. So there's no upper house when it comes to provincial legislatures. The legislature, of course, as you know, is tasked with lawmaking and budgeting. So when you're talking about budgeting, we're talking about money bills. The money bills can only originate in and be passed by the National Assembly because it's directly elected. But for the rest, whether it's a constitutional amendment bill, whether it's a regular statute being amended, or new statute being introduced, new bill being introduced, all of those can essentially originate in either house. And then we come to the judiciary. So again, when you're talking about constitutional law, you're only concerned or primarily concerned with the 3 tiers of constitutional courts. So we have 5 high courts at this point. The original jurisdiction comes under 199. Then we have the Federal Shariat Court, original jurisdiction coming under 203D. And then we have the Supreme Court, where the original jurisdiction, of course, comes under 184.3. It's also interesting to note that the Federal Shariat Court is the only court in the legal system which has explicit suo motu powers granted to it within the text of the Constitution. The Supreme Court's suo motu powers was something that were derived as a consequence of evolving precedent and relying on comparative constitutional cases also. It's also important to know how judges are appointed to these 3 courts. So that's done through Article 175A, which again was a new process under the 18th Amendment, and the 19th Amendment essentially sort of tweaked it. The judicial appointments essentially first go to Judicial Commission, and those who are approved then go to the Parliamentary Committee, the powers of which were significantly reduced under the 19th Amendment. So it's primarily in terms of functional utility, it's primarily the Judicial Commission that's doing the judicial appointments or responsible for judicial appointments at this point in time, because the Parliamentary Committee really has been left toothless. Then 2 sort of controlling mechanisms. Number 1 is contempt of court. Contempt of court, the concept of procedural contempt of court, of course, exists throughout the entire hierarchy of our court system. So even when you're talking about lower courts, civil courts, criminal courts, special courts, there's some level of contempt will always exist if, let's say, you're being disruptive, if you're intentionally not following court orders. But when you're talking about substantive contempt, that's essentially when we're talking about a situation where you by your words or your actions or your overall expression are ridiculing the courts. And that protection to the courts is only granted to the high courts and the Supreme Courts under Article 204, and which is supplemented by Article 19, which is right to which is freedom of expression, where contempt of court has been mentioned as an explicit exception to the to expression, or legal expression for that matter. And the Supreme Judicial Council is another important thing. So when you look at, for instance, I don't know, functionality of NAB or other sort of code of conduct issues originating from the judiciary, when it comes to the constitutional courts or the higher courts, there's only one avenue where you can take any misconduct cases, and that is the Supreme Judicial Council under Article 209. And that's essentially it for constitutional law. But again, it's a very deep, it's a very expensive subject. But again, it's only 10% for you guys. So hopefully this will provide you some insight into what are the key areas that you should at least always remember going into the exam.
Thank you very much, Marva. That was great.